This is traffic ticket defense attorney Michael Beer, 516-569-4107, Beerlawyeroffice at gmail.com, or also we have a address of ask@trafficticketlawyer.net. So today's question is a follow-up to yesterday's question. What are the circumstances under which a police officer can request an adjournment by himself or through his coordinator? So let's say you have a court date scheduled for today. If the officer knows in advance that they're going to be unavailable, their coordinator can request an adjournment from the police department in advance of that hearing. They can do that by submitting the request at least 7 days in advance. If it's more than 7 days in advance, 7 or more days in advance, it's routinely granted on the first or second request in advance. If it's less than 7 days in advance, then it should not be granted. And there's really no list of reasons why that request, for the request. So it could be anything from unavailability, vacation, any type of reason. If the police department wants to put it off in advance, they can get it in advance more than 7 days without any problem, up to twice, generally. If the police officer does not appear for a hearing without providing 7 days notice, the charge should be dismissed unless the failure to appear by the police officer is one of the following reasons: death in the police officer's family, sickness or injury of police officer, the police officer responding to a crime or violation, a conflicting court appearance, or police emergency. There are circumstances where those rules can vary, and those include where the police officer has failed to personally appear if the charge is one that is considered a required appearance. And that could be many reasons. The most common are insurance ticket, points problems, failure to yield right-of-way charges, as well as multiple speeds or other license-related issues. Also, the law provides that in exceptional or unusual circumstances, the judge can vary the procedures and either dismiss or refuse to dismiss based upon the unusual or exceptional circumstances. The law also says that if the hearing was adjourned once before for the officer for any of those 5 reasons stated earlier, or because the charge was one that had a required appearance, the charge shall be dismissed on the second non-appearance of the police officer with less than 7 days notice, unless the judge in court determines that the dismissal will cause a substantial traffic safety hazard. And that's a very loaded question, that last part, and what it means. And obviously there has to be some sort of statement on the record that the judge reviewed the record of the motorist, and the history of their license is so terrible that even this violation would shock the conscience by dismissing it. So those are the basic reasons why an officer might be able to request an adjournment either in advance or on the day of the hearing. If you have any other questions you want answered, please send them to me. And of course, if I use them on my video, you're entitled to a mask sent to you. So send them to me either below or by email to beerlawyeroffice@gmail.com or ask@trafficticketprofessor.com. Have a great day and back to court. Thank you.